I agreed with the broadcasters that what Aereo is doing looks a lot like what a cable system does.
And that wasn't the only thing they did. The Supreme Court has limited the president's appointment powers, and this week lowered another boom on law enforcement. No checking into someone's cell phone without a search warrant. Already there are plenty of people wondering what is next in trying to catch the bad guys in the act while still keeping tabs on personal privacy. You have Aereo and so much more. It's another day in the life of the Supremes, and now making sense of it all in the real world. Welcome to Midpoint, constitutional law professor, political strategist, and best-selling author of The President's War. Chris DeRose joins us today on Midpoint. Chris, thanks so much for being with us.
Thanks for having me.
Chris, we have so much to talk about here. We got to catch up on this.
It was a busy week for the Supremes.
It's been a stunningly busy week in everything that's going on. Want to start out with something because this is an anniversary here today, too. This is the first anniversary of a SCOTUS's decision striking down a portion of the Defense of Marriage Act. While we talk about that, then just yesterday, Indiana's ban on gay marriage was ruled unconstitutional. So this is a snowballing effect here. I think that what we are seeing here is, quite frankly, there is no stopping it at this point. Those who say that you can find a way to stop the gay marriage allowances somewhere here in America, it's just not going to happen, correct?
I think that's right. I think we are heading toward a point where it is inevitably the judicial holding of the country that gay marriage will be legal in every state. So we've seen one state after another, the marriage laws have fallen like dominoes. Here's what I think is going to happen. I can come back on the show and take credit for this at some point if this is what the Supreme Court does. So you saw how they skirted the issue in the DOMA case last year, right? Mm-hmm. Where they refused to find a fundamental constitutional right to gay marriage. Supreme Court wants to steer clear of these contentious issues. So here's what I think they'll do instead. The Ninth Circuit recently, in the GlaxoSmithKline case, found that there is a higher level of scrutiny applied to laws that classify people based on sexual preference. So that was a case where a gay juror was challenged simply for being gay in a case in California. And so the Ninth Circuit has held that being gay is a protected class, more similar to the protections that courts have for women, than to be reviewed under rational basis, which is the lower level for review. And so what I think the Supreme Court may do is take that GlaxoSmithKline case, hold that being gay is a protected class, and then other courts throughout the country can use that to shoot down any remaining marriage laws that limit marriage to one man and one woman.
Let us then move on now to the one that I spoke about early on, and that is the thing that a lot of my friends in law enforcement are talking about as well. Phones cannot be searched. We're talking about cell phones without a warrant here. I'll be very honest, a couple of the law enforcement professionals that I spoke with said, how are we now supposed to do our job? Because that is a key manner in which that we are able to gain evidence. However, on the other side, there are those saying, wait a minute, those phones are your property. They are personal property. They contain personal messages. It is just the same as going into some people's homes. Make some sense of this for us, will you please?
I think this is a huge victory for the Constitution and for our privacy rights, which are very much on our minds today. With NSA issues, Edward Snowden, we're concerned with increasing technology and the advantages it gives the government to pry into our lives. We're concerned about what remains to us to keep private and to keep secret. And so I would, number one, start, I guess, by asking law enforcement, what they were doing and how they were building cases 15 years ago before cell phones were ubiquitous. Certainly we were solving crimes before then, and we were able to build cases before that. But all this requires is that a judge the judge issue a warrant, the judge find that there's a probable cause that something incriminating is on your cell phone. But for police to be, the state's lawyers argued that this was akin to opening up someone's cigarette pack and looking in their cigarette pack to find something. Cell phones are a very different deal than a cigarette pack. People have photos, videos, text messages, emails, very personal information, sensitive information that we don't want to be shared with the government without a warrant. The Supreme Court still allows for emergency situations, so the proverbial ticking time bomb situation or a child being held hostage. If there's an exigent circumstance like that, similar to other exceptions to the warrant requirements, a warrant's not necessary. But typically speaking now, Supreme Court has ruled that we're going to need a warrant to search our cell phones.
What you just said is going to be my next point. You talked about those exigent circumstances. That is, should the police confront an authentic now or never situation, according to the Chief Justice, they may well be entitled to search the phone under a separate strand of the Fourth Amendment law. Now there's something else. We're getting into technology here, though, because more and more we're finding ways to hide information. Here's something else, according to Chief Justice Roberts. He says the possibility that evidence could be destroyed or hidden by, quote, remote wiping or encryption programs was remote, speculative, and capable of being addressed. That's pretty broad, actually, if you ask me, because there's an awful lot of programs out there that do these. So if you're a little tech savvy, there's a number of ways to cover up what you have on that phone by using some of these things that the Chief Justice says is a remote possibility. Would you not agree?
Well, what the Supreme Court holds in their decision, and no one's going to give the Supremes credit for being the most tech-savvy 9 people in the world. Right?
Okay, that's fair.
No one's ever confused them for that. But they do make some reasonable points. And so to prevent the remote wiping of a cell phone, police officers have the option of removing the battery, shutting the cell phone down. So they have options to actually preserve evidence. Because obviously in any other situation where evidence is in the process of being destroyed, that's an exception to the warrant requirement. So people can charge into a building, for instance, if they think a crime is happening, or they hear you flushing the toilet. You're there to serve, you're there on suspicion of arresting someone for a drug crime, those sorts of exigent circumstances. So the court says even in cases like this, the state didn't have many examples of people remotely wiping their cell phone drive when it's within an evidence cell somewhere. This just wasn't happening, and even if it was, there are measures the state could take to protect from it.
Something else here, the free speech rights of abortion opponents, the court ruling unanimously that Massachusetts went too far when it created 35-foot buffer zones around abortion clinics to keep demonstrators away from patients. Break this down for us, would you please?
Big victory for the First Amendment, because we know at least 5 justices on the Supreme Court believe that there's a fundamental constitutional right to have an abortion. And so this was a big victory for free speech. Obviously, at least 5 justices on the court not sympathetic to the pro-life arguments being made outside of these abortion clinics, but finding that Massachusetts' law, which created a 35-foot buffer, was too far for people to effectively exercise their First Amendment right. There are people who will stand outside abortion clinics, who will try to encourage women going inside to make a different choice, to let them know about alternatives. And so at 35 feet, especially in an urban area, you're not catching anybody going into or out of these clinics. And so the Supreme Court correctly found that this was too unreasonable of a burden on our First Amendment rights. And additionally, the Massachusetts law actually had an exception for clinic employees. So what you would see is pro-life demonstrators would be forced to stand 35 feet away from the clinics, but the abortion clinic employees could come outside and actually engage in free speech to tell the potential patients, don't listen to these guys, they don't know what they're talking about, let's keep walking, let's go into the building. So they could exercise their free speech rights within the buffer zone, but pro-life opponents of abortion could not exercise those same exact First Amendment rights in the same buffer zone.
Chris, one more thing, couple of minutes we have left here, and this really shocked a lot of people here. The court limiting the president's power, and this was a direct strike at the Obama administration, to fill high-level vacancies with temporary appointments. This goes back to some NLRB confirmations that the president had made a couple of years ago, basically saying that without Senate confirmation, they were illegal. This is a huge decision.
I think it is a huge decision. I think we've looked increasingly, those of us who are advocates of a constitutional framework, we have a president who talks about working around Congress, a president who blames the founding fathers for his inability to get his agenda passed, who doesn't seem to really like the idea of separation of powers. So what President Obama did was he made a decision that Congress was not in session. Congress did not agree that they were not in session. They argued that they were in session. So this was tested, this proposition was tested over the recess appointment, which the founding fathers put into the Constitution in an era where Congress did not meet for most of the year, and before jet travel allowed members of Congress to move quickly back and forth between D.C. and their districts. And so what the president did was he took this recess appointment power, the power the president has in the Constitution to fill vacancies during a recess. He decided the Senate was in recess, even though they said they weren't, and made these appointments anyway, totally sidestepped their advise and consent power to prevent these nominees from reaching the National Labor Relations Board. So I think it's a big victory for the rule of law, a big victory for the Constitution, and a stunning rebuke to this president who has increasingly acted as though the Constitution and the rules don't apply to him.
Hate to do this. I only have 20 seconds left. The Aereo decision, was that much of a shock? Because really it was almost in many people's minds theft of copyrighted material.
Yeah, you know, I'm an author, as you pointed out. My book, The President's War, came out this week, and I love the fact that I get royalties from sales of The President's War. And similarly, content producers want to make money off of their content that they produce. And so Arrow was providing public performances of their content and making money from it. And so it's not, I don't see it as a holding with wide-ranging complications. I think Arrow will find a licensing agreement with the networks, and everybody will be happy. They'll find a way to stay in business.
That's exactly what will happen. Try to skirt it first and then go ahead and go for the money afterwards. Always a pleasure to have you on the show, Chris. Thanks so much for joining us today.
Thank you. Pleasure is mine.
All right, making sense of what the Supreme Court had to say. You make sense of it and tell us what you think on Twitter, hashtag Midpoint, also on email, and also go to the Facebook page. Leave it there, /Midpoint TV, because here on Midpoint every day we question everything.